you've been going through the coursework of the Prudent Money Project, you know that I did a teaching course on life insurance and how to set up a life insurance plan. And today I want to talk about estate planning. This is one of the courses that I thought about that, I want to include this information. And let me say up front, I'm not an attorney, nor am I trying to play one on a video teaching course. Okay, so I'm not an attorney, and all I want to do is teach you the concepts of estate planning so that when you go in to see an estate planning attorney, one you've selected, and we'll talk about that as well, when you go in to see an estate planning attorney, you're going to know exactly what to ask and the questions to ask, and you'll conceptually understand what's going on because of going through this video. So keep in mind, we're not getting into the broad-based details of how these things are set up and the technical aspect of it. We're talking about the broad strokes of estate planning. Now, what is estate planning? Estate planning is simply this. It's the transfer of assets from one generation to another generation. And if a husband or a wife precedes their spouse, that transition of assets stays within their family. I mean, it automatically goes to the surviving spouse. But when the second spouse that's survived passes away, then those assets transfer from one generation to another generation. And that generation could be made up of a blended family. That generation could be older adult children. That generation could be kids. The bottom line is there's got to be a mechanism in place to transfer those assets so that legally you can take ownership of it. Whether that's an investment account, whether that's a home, whether that's a piece of real estate, whatever it might be, the estate planning process is very important. Now, a lot of people think, I don't have enough money to do estate planning. Estate planning is only for the rich. I would totally disagree. Now, estate planning for people who are pretty wealthy is a very important task to go through because it acts as a protection mechanism, and there's a lot of aspects of it that go to work with their size of an estate. But this is basic estate planning that I want you to get. This is for the average person. This is for us. We're going to talk about what makes the most sense and how it all works. Now, I will say this, that as I go through this, my generalizations and observations of how this works might make an attorney cringe. My apologies ahead of time, but I think you'll get the idea of what I'm talking about. Let's start with the basics. You create a will. If you create a will, that is better than having nothing at all, but that is a way to talk about and dictate what your wishes are. The problem is a will is easily challenged in a court of law. If there's a misunderstanding of what the meaning of the will, there could be challenges from any of the heirs. There can still be problems. It's better than nothing, but the bottom line is it can be challenged. Plus, it has to go through what's called the probate process, and a judge signs off on it as this can take place. And so the executor of the will take care of the assets. It's better than nothing. And if you have, and I talk about three different scenarios, the most important scenario is the one where you have small kids or even teenagers that in the event that something happens, and I call it the nuclear option, something happens to both of you, the husband and the wife, you pass away at the same time. It's a low probability of happening, and it's still a probability of happening. And I know in talking with people through the years that they worry about this. I worried about it until I got my estate planning set up to make sure that my kids were taken care of as I wished them, as I wanted them to be taken care of. So the best way to do that is to create a trust. Inside of a trust, and this is kind of crass, so you have to excuse me, but you get the point. It gives you the ability to control their environment from the grave. It's not just a wish list. It's an ironclad legal document that has provisions in it that tell exactly what you want to happen for your kids. And in the event that I call the nuclear option, where both parents, something happens to them and the kids are left without parents, then this trust, which is administered by a trustee, will have all of your wishes listed out down to the very detail of detail. And by law, that trustee has to administer that trust based on the language in the trust. It's a great planning tool, and if you got kids, I would advise to make sure that you have this mechanism set up to make sure that they're taken care of. Now, what a trust dictates the following. It talks about when they can get money. So let's say, you could leave two teenagers or two younger kids, you could leave them $1 million+ through life insurance. Both of you having life insurance policies, modest even life insurance policies, a home, you name it. So you want to dictate when they can get that money and how they can get that money. So it comes down to most people set it up to where their college education is taken care of, their living expenses are taken care of, reasonable amount for a car. If an 18-year-old comes to the trustee and says, "Hey, I want to buy an $85,000 Porsche," probably not reasonable, so the trustee's probably going to turn that request down based on the languaging of it. But it does talk about the provisions of how they get money, and it just dictates everything as far as what happens to the kids financially. It can take care of special needs. If you have a child with special needs, you can set up a special needs trust to take care of them. When the money's distributed. And most importantly, it also identifies the guardians. And there's no discrepancy about who the parents wanted to be those guardians. Now, I always advocate selecting a team of people. What I don't advocate, and I'm sure most attorneys would agree with this, is that you take one person and say, "Hey, you're the guardian, you're the trustee, and you oversee the money." That's giving one person too much power. There's no checks and balances, nobody to oversee their actions as trustee or as the person taking care of the money. It might be that they get into a debt situation and they choose to take money out of the trust to pay off their debt with the good intentions of paying it back, but nobody's watching. And anything could happen. People change over time, especially when it comes to money, or can change because of money. Maybe the person develops a gambling addiction and they run through half of the amount of the trust. Who knows what could happen? But have a trustee, have a separate person who's the guardian, and then have a person who is overseeing the investments and the planning of the money. Now, what I see happen with most people is it comes down to just shutting the process down automatically when the attorney looks at them and goes, "Who's going to be your guardian? Who are you going to select to take care of your kids?" And the first thing that comes to your mind for most people is, there's nobody as good as me at taking care of my kids. And you're probably right. There is probably nobody that's going to take care of your kids like you're going to take care of your kids, but they're going to be as close as possible. So you're looking for that person that's as close as possible, but no one will be as good as you. So don't spend a lot of time arguing over and debating who it should be. Just pick the person that comes close to resembling the values and the goals that you would have for them, and select them as a person. And you also have to have backups too, in the event that the nuclear option includes the people that you chose as guardian. Estate planning for adult children. I've unfortunately witnessed many times where a second parent passes away. The assets are there to shift to the adult children, and the adult children have a bad relationship, or they own all, or some of them have a bad relationship between each other, and there's a lot of arguing and fighting and bad blood over who gets what. Now, the will says this is what's supposed to happen, but the oldest son says, "Well, yeah, but Dad told me that I'm supposed to get that piece of property no matter what because I'm the oldest child. I know what he put in there, but obviously he's mistaken, so I'm going to challenge the will." It can be an absolute mess. You don't want your adult children to have any ability to challenge, to make decisions. That's why setting up a trust is still a great gift to give your family, even with adult children, because you can break everything down. This is what I want. This is who gets what. Trustee, administer this as I've said. Case closed, case done, and that's the benefit of the trust for adult children. Estate planning for a blended family. Now, this is what can get really toxic when you've got a second marriage and two sets of kids. Those kids could think that they are entitled to certain things. And this is also a good conversation for the husband and wife to have about how their own kids are going to get taken care of. But do make sure that you do go through this process if you have blended families, because it does take the decision making out of their hands, the challenging out of their hands, and just says this is who gets who gets what. This is set in stone, and this is the way the trustee is going to administer it. One other important document is the power of attorney, and I just want to illustrate. A power of attorney it comes into effect when a person cannot make decisions for themselves. It's a very important document to have because you never know what could happen to where they could make decisions for themselves. Now, considering that most people have the bulk of their net worth tied up in individual retirement accounts or 401k plans, without a power of attorney, this could be a problem. And I just want to identify this one particular situation because it's a scenario that could end up being a huge problem. So let's say that the husband has $1 million in an IRA, and that $1 million is there for their future. The husband goes into a coma, cannot make decisions for that $1 million. Guess what happens? That $1 million in that IRA gets frozen. The wife can't touch it without a power of attorney. And it's so very important to make sure that you have that in place. And there's you also want to make sure that you get a power of attorney written by someone who does estate planning so there's no mistakes, so that's very reputable, because a brokerage company or any company can say, we don't feel like that power of attorney is valid, and so they don't have to accept it. But if it's done right, that eliminates that, starts to eliminate that particular problem. But you got to know that, and it's also one of those things that where you get that power of attorney done, you give it to your financial advisor and say, make sure that this is acceptable in the eyes of the broker dealer, and to make sure that who makes the decision on this, so that you know that you don't have a problem with it. But a power of attorney, very important to have, especially in a situation where you have all the assets tied up in a spouse's name who can't make decisions for themselves. What about do-it-yourself estate planning? There's a big industry out there that says, buy this software, plug in the names, and you're done. Too much room for error that you could make. Laws are different by each state. You could make an error. You can make the document invalid. And plus, do you think a judge wants to look over a document, say it's a will, that is homemade versus one that's done by an attorney? Do you think there would be any biases there? Could be. To me, it's not worth the cost of savings. Get a legitimate attorney to do the will, to do the trust if needed, and to get it taken care of the right way. Now, find a good estate planning attorney. There's all types of estate planning attorneys. As I said, there's estate planning attorneys that work with the average Joe. There's estate planning attorneys that work with very wealthy people. Ask around, because you don't have to spend a lot of money. Be able to, once you've figured out who you're going to use, make sure that when you go to the meeting that you're able to name key people, the guardian, the trustee, the person who oversees the money, and their backups, because that's required as well. What I find is that people go into estate planning meetings very unprepared knowledge-wise, and that's the whole idea of this teaching course. Be able to talk about your wishes. Say, here we are. This is where we would want to be in the event of the nuclear option or the event of a second death. And whatever you have to do to connect A and B, that's what we want to do. Once you finally get the documents done, they're executed, they're signed, they're notarized, they're witnessed, make sure that they go into a safety deposit box where somebody knows where they are, or a safe where somebody can get access to it, because I've seen too many times where originals get lost, and makes it for a very complicated situation. Best piece of advice that I could give you is to do it now. Make sure that you've gone through the estate planning process. In fact, I think that there is no excuse for any family, especially a family with young kids. There's no excuse for not going through this process. There's no excuse for not getting the life insurance aspect of the estate plan put into place, because you just don't want to take that chance with your kids. You want to make sure your kids are protected. You want to make sure your adult children are protected. And the transfer of estates from one party to another party can be tricky. So it's important to not put it off, to get it done now and make sure that your family is protected in the event of an untimely death.